Hello everyone. So in this video lecture, we will be dealing with false evidence in offences against public justice. So the first section would be section 227. So this section deals with giving false evidence. So when a person is legally bound and he has taken oath in the sense he has to tell truth in every circumstances. So when he's on oath or when there is an express provision under the law that you should not make false statement, in such case the person knows or he believes such evidence is not to be true, makes false statement, he commits an offense of perjury under English law, and under Indian law it is an offense under section 227. The key thing is the person administering oath should have jurisdiction to make such person who has made false statement to make him liable. And illustrations would be, it could be false statement could have been made during trial, or he knows that the person's handwriting but still proceeds to make false statements. Then um, he makes alibi, uh, he makes false statement via using alibi. And any false statement that has been made by interpreter or translators, because these are very crucial when it comes to criminal convictions. And when such interpreter with criminal intention make such false statements, and they could be held liable under this section. There is a case law for this, Hari Charan Singh versus Queen Empress. So in this case it has been held that a person is not legally bound to make truth to make true statements uh, before trial. So generally, um, um, a person can only be bound to state true facts only during the trial and not before the trial. So advocates are not generally legally bound by law to make only true statements. Hence, they may proceed to make false statements, which is generally not advisable. KTMS versus Union of India. This is a case where it has been held that before convicting a person for false statements, the court should ensure and should test whether the person had criminal knowledge or intention uh, to make false statements before convicting. That is really necessary. And under this section 226, there are some explanations have been given. It is not that statements have been made only through verbal means, it can also mean otherwise. And explanation 2 deals with making persons attesting liable, so they can also be brought under this section. And section 228 deals with fabricating false evidence. So whoever creates any entry or makes false statements in books, records, or e-records, in such case, making such fabrications with intent that such evidences could be used for the purpose of judicial proceedings, or make such um things before any public servant or even arbitrator, which leads in passing an erroneous decision by court in case of judicial proceedings. So that is also an offense, and it is not just an act but it also includes omission as well. And section 229 deals with punishment. So in case of judicial proceedings, the punishment would be 7 years plus fine. And in case of in otherwise, like in case of public servant, before public servants, or arbitrator in case of arbitration, 3 years imprisonment or fine. would be imposed. Explanations are given for this section. The term judicial proceedings also includes court martial proceedings, and explanation 2 deals with it is not just about pure judicial proceedings is equal to judicial proceedings. It may also include any investigation order has been mandated by magistrate or preliminary investigation that could also be construed as judicial proceedings, and uh, same shall be covered under this section. Explanation 3, it deals with any investigation that has been mandated by the court that could also be construed as a judicial proceeding. And the case laws, when coming to case laws, Narendra Kumar Srivatsava versus State of Bihar. In this case, it has been held that an complaint for false evidence cannot be made through private complaint. It has been made like that. Only the court can take uh, cognizance of that particular false evidence complaint. It cannot be done through private complaint. Lalji Haridav versus State of Maharashtra. In this case, income tax officials can also be covered under this particular section, so they can also be construed as judicial proceedings and make persons who are giving false evidences in case of income tax proceedings, and they can make such persons liable. So, but it is important that rent controller will not be covered under this term judicial proceeding because they are quasi judicial nature. Section 230 deals with um, when a conviction has been made, and the conviction is the consequence of the false evidence that has been provided. When such conviction leads to any capital punishment, life imprisonment, and 10 years of rigorous imprisonment, the same punishment shall be given for the person who has given false evidence as well. And uh, that has been provided under section 230, and section 231 deals with when a person is convicted and the consequence of such conviction is life imprisonment and 7 years, same punishment as well to the person who is making false evidence. And section 232 deals with when uh, false evidence has been given by the way of threat. When a person threatens to give false evidence, an injury has been caused, then the person who is threatening to give false evidence will also be liable for the same offense if such punishment exceeds 7 years death or life imprisonment. And section 233 deals with using false evidence. So when a person has knowledge that it is a false evidence, though he uses or attempt to use, so it is not just about using it, it also includes persons who are attempting to use it, then same punishment for fabricating false evidence would be imposed. Section 234 deals with issuing or signing false certificates. So there will be certain certificates which will be required by law, or such certificates are admissible as an evidence in the court. In such case, when a false certificate that has been issued or signed, then such person shall be liable for the punishment as same as he has made false evidence. Section 235 deals with using false certificates. So when using false certificate, so 234 deals with issuing and signing false certificates, and 235 deals with using such false certificate. Same punishment as giving false evidence will be imposed, and such persons shall be liable for the same. Section 236 deals with false statement in declaration. Any declaration that has been made which is admissible in the court or under the law, and such declaration has been made voluntarily but not under the oath or any other law, then the person shall be made liable under this section. But the key thing is to know is that the person making such a false statement must relate to the declaration that he is making to. Section 237 deals with using such false statement with knowledge. When a person makes any false statement with the knowledge that he is making false statement, he shall be liable under this section, which is 237. Under section 238, when a person uh, makes disappearance of evidence or false information to screen offender, generally to save culprit. So the whole purpose is here to save the culprit, and he uh, makes the evidence of information disappear in order to save culprit, then he or she shall be liable under this section. And the case law for this section would be Dinesh Kumar Kalidas Patel versus State of Gujarat. So in this case, it has been held that false information is an independent conviction, and it is not necessary that false information has to be made only by the accused. No, it is not like that. The false statements can also be made by other persons, and they will also be held liable, and they will also be punished for as if they have committed a separate offense. So it has to be treated independently. And the next case law is Kalavati versus State of Himachal Pradesh. So under this section, the main offender has committed murder and has been charged for the same. But Kalavati, who is not the main offender, gives false evidence in support of the person who have committed murder, the main offender. She also commits offense here because she is making false evidence and statements in support of main offender. So she'll be treated independently and she'll be liable for the same. Section 239 deals with intentional omission to give information. So when a crime has taken place, every witness or any person who were there that particular incident and knows such commission of such offense is bound to give information to the police officers and magistrates. When such persons do not comply with law or doesn't make or omits to make with intention to give evidence, to give information, then they can be liable under this section. They can be held liable under this section. Section 240 deals with when offense, after all, it has not been taken place, but still the person proceeds to give false evidence to, to support such offense, has committed an offense under this section 240, and shall also be punished for imprisonment of 2 years or fine. Section 241 deals with destruction of evidence, a document or record. So this such destruction is being made to prevent such evidence from being produced before the court. So that is an offense. It could be before or after issuance of summons. Section 242 deals with false personation. So when a person has to be made, uh, has to be produced before the court, and he should make admissions or statements or confessions when false personation has been made with such persons, and an admission or statement or confession has been made with regard to that, and such confessions have been made in a false personation way in any suit or proceedings, then they shall be held liable under this section 242. And section 268 deals with false personation by assessor. So when an expert has been appointed by the court of law to give evidence, for example, surveyor in case of civil suits, when he commits false personation, he shall be held liable for the same. So that is dealt under section 268. And section 243 deals with fraud removal or concealment of property. So when an order has been made by the court to seize such property, or a forfeiture order has been made by the court, so when uh, the person conceals or disposes it, such property upon which the court has ordered for seizure, when such person conceals or disposes, such property shall be liable for the same under section 243. And section 244 deals with fraudulent claim to prevent seizure or forfeiture. So fraudulent, he the person who is holding the property upon which the court has ordered for seizure of forfeiture um has appointed a person to make false claims so that um, he can get benefited out of it, or he can delay the procedure with such intentions. If any person uh, allows any fraudulent claim, then such person shall be held liable under this section 244. Section 245 deals with fraudulent person suffering of degree for a sum not due. So when a person is not at all at due, uh, when there is no due, there is the sum is not due at all, even though fraudulently he represents that he is suffering, and he has some sort of interest over such property. So all these dramas has been made by the person who holds the property now, and the court has ordered for seizure. And when the person who holds the property um, appoints a person to has a defendant to make some claims, that representing that he has claims over such property, and thereby um, fraudulent in making such person party to the suit as a defendant by allowing him to put false claims that so and so money is due over such property, and obtaining sums fraudulently, he has committed an offense under this section 245. So appointing a person as a defendant for getting benefits upon a property which has been ordered for seizure. And section 247 deals with when false claim has been made when he is a plaintiff after all. So we have dealt section 245 where he's appointing the defendant, and he's making the person party as a defendant, and the same is here. He's not a defendant here, he's a plaintiff itself. So in such case he shall be liable under section 247. Section 246 deals with in dishonestly making false claim in the court. So generally, if any false claim has been made in the court with dishonest intention, such person shall be punished for an imprisonment of 2 years with fine. And section 248 deals with false charge of offense. with intent to injure. So when any criminal complaint has been filed and thereby charging him for an offense which he has not committed, which is false charge, of course, then there should be an intent to injure such person and makes a false criminal complaint. So such person shall be liable under this section. It's a criminal liability. Section 249 deals with harboring offenders. So generally, harboring has been defined under Section 2, Clause 13. So when a person assets or giving harbors, he harbors the person who has committed crime, for example. So when such person harbors, he shall also be liable and he shall also be punished. But there is an exception for this. Wife or husband, the spouses, they cannot be held liable under this section, but does not include parents. So there is a sort of immunity that has been provided for husbands and wives. Section 250 deals with taking evidence, and section 251 deals with offering gift for the purpose of harboring. And section 252 deals with taking gift to help recover stolen property. So for the purpose of concealing that there has been a stolen property, and in furtherance to that, if any person um in charge to recover such stolen property takes gift and does not recover such stolen property, such person shall be punished under the section 242, 252, beg your pardon. Section 253 deals with when a person has been escaped from custody. So he has been a person who has been ordered for apprehension, for arrest, or he's escaped from custody, and when such person is being harbored by any persons, so harboring such persons also a punishment, is also an offense under section 253. And section 254 deals with penalty for harboring robbers and dacoits. So they have committed some serious offense, right? Who have they have committed robbery and dacoity, and harboring such persons would lead to punishment of 7 years of imprisonment with fine. Section 255 deals with disobeying directions of law. So if any public servants, so public servants are generally bound by law, and if they the public servants, they do not obey law or they disobey directions of law with intent to save a person or property, in such case they shall be held liable under this section 255. And section 256 deals with public servant as well, because when the public servant makes any incorrect record, that could be in writing as well, with intent to save a person or property. So under section 255, the public servant is not obeying directions or disobeying directions of law. And section 256, the public servant is making incorrect record. And for both the section, the objective is same, that is to save a person or property. There is a case law for this, Kondali Purnachandra Rao versus PP, I assume that's public prosecutor of state of Andhra Pradesh. So a public servant makes a record that there has been no injuries has been sustained in the woman's body, and yeah, this case it has been held, he has committed an offense. Section 257 deals with public servant making a report. So such report could be used for the purpose of judicial proceedings, and The public servants make such report contrary to law with corrupt intention and with malicious kind, he commits an offense under this section 257. So public servant should not make report that is contrary to law with corrupt intention. Section 258 deals with when trial has been committed um, or confined person by authority. So when a person has authority to commit a trial to another court or has power to confine a person under authority of law, when he goes against law, when he carries away such powers contrary to law, they shall be held liable under this section 258. Section 259 deals with intentional omission. When a public servant is bound to produce a person committing offense before the court, omits to do so with intention, maybe for saving him, so he has duty to produce him before the court. He intentionally omits to do so, thereby commits an offense under this section 259. And section 260 deals with allowing person to escape. The person has been convicted for an offense and allowing such persons, and this is done by public servants intentionally, so they shall be held liable under the section 260. Section 261, it deals with when public servants allows the persons convicted or the persons confined or in custody to escape by the way of negligence, then they shall also be liable under section 261. Section 264 deals with when a person with intention or negligence, the public servant um, facilitates escape or he omits to confine that person with intention or via negligence, then they shall be liable. The public servants shall also be liable under this section 264. So this section attracts um, when public servant is not attracted by section 221 to 22 and 223. Only then the public servants shall be liable under this section 264. Section 262 deals with any resistance or obstruction that has been made. uh, for example, an arrest order has been made, a lawful apprehension order has been made against an accused to make him arrest, and when accused resists, that is not cooperating generally and makes resistance and obstructions, then there can be some extra punishments that can be imposed upon the accused for making such resistance and obstructions.